Ms. White, would you like to come forward? We'd be happy to hear from you.
Yes, Your Honor, and may it please the court. My name is Jack White, and along with my co-counsel, Kevin Burns, who was also counsel below, I represent appellants Derek and Lisa Kitlinski. This case is about preventing government agencies from using their quasi-criminal investigative functions to intimidate employees in the midst of legitimate ongoing investigations, particularly when it runs afoul of USERRA. To that end, this court should reverse the decision of the district court for the following two reasons. First, the district court erred in disregarding genuine issues of material fact and granting summary judgment in favor of the government. And second, on de novo review, the undisputed facts here should lead this court to grant summary judgment in favor of Derek and Lisa Kitlinski. Now, at the outset, Your Honors, this court's analysis of the events that led to the respective wrongful terminations of Derek and Lisa Kitlinski should be undertaken in light of ongoing litigation that was brought by Mr. Kitlinski against the DEA. Inadvertently or otherwise, the government has clogged the record with the suggestion that the ongoing litigation either was already resolved, which it was not, or was immaterial, which it is not. As a matter of fact, the BlackBerry device that the Kitlinskis were sought to be questioned on was found on Lisa's vehicle in the midst of the underlying litigation that was ongoing by Derek against the agency. And this was the very topic that the agency wished to question both Derek and Lisa on under oath and terminated them for not participating in this sworn deposition. Now, to my first point, the district court erred in disregarding genuine issues of material fact. Those issues focus on the authority that the DEA had over Derek to even call him in for questioning. Now, in order to appreciate that authority, it's important to be mindful of the applicable statutory scheme. The Uniformed Services Employment and Reemployment Rights Act was passed and subsequently strengthened because we are a nation that has been at war for nearly 2 decades. And the basic purpose of the statutory scheme is to ensure that service members who leave their civilian employment and serve honorably in support of the mission of the United States military have the assurance that once their service is completed, they will be able to return to their civilian careers with as little disruption and difficulty as possible. Here, calling Derek to testify disrupted his military service. Moreover, the agency had no authority to call him in to do so.
Are you saying that the investigation is beyond the authority of the Office of Professional Responsibility? It would seem to me if there was a BlackBerry placed under the hood of Lisa's car and the BlackBerry was of unknown origin, that the agency might want to look into it. And the government contends here that Lisa actually asked the DEA to initiate an investigation. So isn't the Office of Professional Responsibility operating within the ambit of its authority? It seems to me it would be something you would want to the agency to look into and find out what was going on. And especially so since Lisa, it seems, was the one that asked DEA to initiate this.
Judge Wilkinson, a legitimate investigation of the placement of this BlackBerry was well within the rights of the agency, but that is not what was going on here. What was going on here was that the agency was seeking to interrogate both Lisa and Derek while Derek was on active duty. Now, the investigation could have gone on while Derek was on active duty. And if the agency really wanted to question Lisa, then subsequently they could have called her in for questioning. That did not happen. As a matter of fact, as soon as Derek returned from active duty and was available for a sworn deposition, the agency could have done so. They did not. Instead, they sought to question him while he was on active duty, and he did not participate because he was on active duty. When he returned to his post at the DEA, he was terminated because he did not participate while he was on active duty. So,
Mr. White, this is Judge Floyd. I thought from the record that the Coast Guard cooperated with the DEA to carry out this interview. Am I wrong about that?
Your Honor, respectfully, that is not accurate. What happened was the DEA sought admission into the location where Mr. Kitlinski was and spoke with certain officials from the Coast Guard who worked on getting them security access. But no one within the Coast Guard had authority by statute to order Derek to leave his post while he was on active duty. So
we're not talking about order him to do something. The question is, did the Coast Guard forbid him from going, or did they intervene in any way? I mean, why could he not go and participate in the interview?
I understand the question. Why could he not leave his post? But the problem there is under USERRA, he was protected from having to leave his post altogether. A brief hypothetical, and I'll be expeditious, but it might illustrate the point. Let's say that Derek was not, it's just a matter of geography and convenience that Derek was located in Washington, D.C. during this time period. Let's say that instead of being in D.C., he was on a Coast Guard cutter, patrolling offshore waters in Southwest
Yes,
Asia.
but the Coast Guard was not interposing any objections here, and the Coast Guard's enabling statute clearly authorizes the Coast Guard to use its personnel to assist a federal agency. And what it envisions is a cooperative relationship between the Coast Guard and DEA here. And just to follow on Judge Floyd's good question, I don't see the Coast Guard interposing any objections to this. In other words, I don't see any reason why he couldn't have gone and been minimally cooperative in the investigation, especially since Lisa had asked the DEA to initiate it. And also, if they're going to investigate, if the OPR is going to investigate, Derek and Lisa would appear to be the people whose whose testimony and interview would be among the most relevant to carry out the investigation. If you don't get the chance to talk to them, you've hollowed out the investigation to the point that it's pretty meaningless.
So, Judge Wilkinson, talking with Derek and Lisa Kidlinski may very well have been pivotal to the investigation. And if the agency really wanted to do that, then it could have done so when Derek was not on active duty. As to the Coast Guard enabling statute, the specific language of the statute says that the authority of any officer is limited to, quote, duty authorized by law for members of the regular component. Now, the Coast Guard did not have the authority to have him go and testify in an investigation with the DEA. It also didn't have the authority to deny him from doing so under the enabling statute, because this type of activity was not authorized, duly authorized by law within the confines of his duties as a Coast Guard officer. As to the fact that Lisa raised the issue, Your Honor, I think it's important to point out that Lisa did cooperate with the interrogation that she was subjected to. She was asked numerous questions, all of which she answered, save those questions that she reasonably believed were protected by the spousal privilege and by her rights under USERRA. Because USERRA, the statute under section 4311B, protects her as well, because she is, quote, taking an action to enforce a protection afforded any person, that being Derek, under this chapter, and, quote, testifying or otherwise making a statement in or in connection with any proceeding under this chapter. I think it's important to appreciate that the questioning that was going on was related to litigation that was ongoing and was brought by Derek. And the attempts of the agency here were to circumvent the investigative process of the litigation that was ongoing and run roughshod on that and get straight to Derek and Lisa by compelling them to testify when the agency not only had no right to do so, but doing so was in violation of the statute. For the reasons that I've set forth here and those set forth in our briefs, we respectfully request that the decision of the district court be reversed. Thank you, Your Honors.
We thank you, and we will hear from Ms. Kimball at this point.
Thank you, Your Honor. May it please the court, this is a case in which two DEA supervisory employees, one a supervisory drug enforcement agent and the other a forensic chemist, flatly refused to cooperate with an internal investigation by DEA's Office of Professional Responsibility, or OPR, which is the DEA equivalent of a police force's internal affairs. Like every other DEA employee who has refused to cooperate with an internal investigation in comparable circumstances, who didn't simply resign, plaintiffs were fired. And even more egregiously, as this court pointed out, the internal investigation here is an investigation that plaintiffs themselves asked OPR to commence. They told OPR that they had discovered a DEA-issued BlackBerry on their vehicle and that they believed someone at the DEA was illegally surveilling them. But then after initiating the investigation, they did everything they could to impede the investigation, until ultimately the DEA fired them for failure to cooperate. After months of discovery in which plaintiffs tried to uncover any evidence whatsoever of an illegal motive of any kind for their terminations, the record demonstrates that none exists. In fact, the district court correctly held, and plaintiffs have not challenged in any of their briefing, that every single one of the facts identified by defendants in their summary judgment briefing including those facts regarding the non-discriminatory, non-retaliatory reasons for plaintiff's terminations, was undisputed. In short, the district court correctly held that there is simply no evidence that any retaliatory animus based on USERRA or Title VII protected activity had any role in plaintiff's terminations. Plaintiffs were fired because they were law enforcement employees who refused to cooperate with an internal investigation. I will address plaintiffs' arguments regarding I will address plaintiffs' arguments that their terminations were retaliation for Title VII protected activity first, and then their claims that their terminations were motivated by their USERRA activity. Then their arguments that they were somehow entitled to an evidentiary hearing, despite the fact that they did not dispute any of the material facts. And finally, I will address plaintiffs' arguments that the district court erroneously forbidden them from reopening discovery months after it had closed and precluded them from deposing the DOJ Inspector General. First, with respect to plaintiffs' claim that their terminations were motivated by Title VII animus, plaintiffs have failed to establish that their terminations resulted from any Title VII retaliation. First and foremost, plaintiffs never even contested summary judgment on their Title VII terminations before the district court, and this court should not consider this claim for the first time here. Second, plaintiffs never identified any evidence showing that their Title VII protected activity had any role in any disparate treatment they received in their terminations. And in fact, the record demonstrates that every DEA employee who refused to cooperate with an internal investigation was terminated or resigned while the termination was pending. And third, the DEA had legitimate non-retaliatory reasons for their terminations, and plaintiffs have never established that those were pretextual. As a forensic chemist and supervisory agent, plaintiffs' job series were two of the most mission critical for the DEA. Mr. Bulgren explained that these types of jobs were held to the highest standard of conduct. And as senior supervisory grade employees, plaintiffs were also held to the highest standard of conduct. Mr. Bulgren explained that supervisory employees stand as an example to more junior employees, and thus must be required to participate in and fully cooperate with an internal investigation. Although plaintiffs now argue that the investigation itself was Title VII retaliation, they didn't argue that before the district court, and there is no evidence that they have identified, even on appeal, that the Title VII investigation was motivated in any way by their Title VII protected activity. As such, because plaintiffs have failed to establish that Title VII had any role in the investigation or their terminations, this court should affirm summary judgment of their Title VII claims. With respect to their claims regarding USERRA, plaintiffs have failed to establish that Mrs. Kitlinski was terminated for any USERRA protected activity. To establish a USERRA claim, plaintiffs must establish that Mrs. Kitlinski engaged in USERRA protected activity and that that protected activity was a motivating factor in her termination. If she establishes those two elements, the government must establish that it would have terminated her regardless of the protected activity. Here, Mrs. Kitlinski did not engage in any USERRA protected activity. Although they now try to argue that her OPR interview was protected activity, it is not. 38 U.S.C. 4311 paragraph B expressly identifies what constitutes protected activity under USERRA. And nowhere in the cited examples of protected activity does it say that an employee can refuse to answer questions in an investigation that she herself began. It simply is not protected activity. And although plaintiffs cited in their briefs to Laughlin v. Emwa and Anderson v. Index Journal Company to try to shoehorn her interview into protected activity, those cases are Title VII cases, not USERRA cases, and USERRA explicitly identifies what valid protected activity under the statute is. Moreover, those cases make clear that oppositional activity can be making statements opposing discrimination short of bringing a claim of discrimination or being a witness in a lawsuit, but that's not what happened here. Not once during the entirety of her interview, which is at Joint Appendix 753 to 808, does Mrs. Kitlinski mention discrimination against any military members or retaliation or USERRA, or even identify any claim that she or her husband had brought under USERRA. Mrs. Kitlinski's refusal to answer questions simply is not protected activity. Nothing in USERRA authorizes an employee to use the statute as both a sword and a shield, as the Kitlinskis did here. They cannot request that the agency investigate potential wrongdoing that they alleged had been committed against them, and then invoke USERRA to refuse to aid in the investigation that they themselves started. Second, the record demonstrates that Mrs. Kitlinski's termination was not motivated by any USERRA protected activity. She was terminated because she refused to answer questions in an investigation, and specifically the questions identified in the notice of proposed termination at Joint Appendix 1059 through 1064. She refused to acknowledge that she had read forms provided to her advising her of her rights and responsibilities in the investigation. She refused to tell the investigators what she personally had done after discovering the BlackBerry. She refused to tell the investigators what her supervisors had told her to do regarding the BlackBerry. She refused to tell the investigators what the Department of Justice Office of Inspector General had told her to do regarding the BlackBerry. She refused to answer whether OPR had told her to return the BlackBerry. And she refused to return the BlackBerry after both her supervisors and OPR told her she had to do so. Although she refused to respond to these questions on the basis of attorney-client or spousal privilege, no one could have believed that either of those privileges applied to these questions, which related solely to what Mrs. Kitlinski had done and to what people other than her spouse and her attorney had discussed with her. Moreover, there is literally nothing in any of these questions or anything in the investigation itself that suggests that the investigation had any basis in an attempt to discover anything going on in her litigation, which at the time was not even existent. The USERRA litigation had been dismissed before her interview and had not been reinstituted at the time of her interview. Moreover, none of the questions that they asked her had any role in trying to uncover what any sort of litigation strategy was or anything along those lines. The questions made clear that the investigators were trying to figure out what had happened with the BlackBerry. And Mr. Bulgren explained that he terminated Mrs. Kitlinski because she refused to cooperate with the investigation. He explained that her job series and seniority required her to be held to the highest standard of conduct, and that her misconduct threatened the integrity of the office because internal investigations are vital to maintaining that integrity. Internal investigations are the primary way that a law enforcement agency ensures the integrity of its law enforcement actions. They're critically important to DEA's mission, and plaintiffs were fired because they flatly refused their obligation to cooperate with the investigation. And finally, Mr. Bulgren's testimony demonstrates that he would have terminated her regardless of whether any USERRA protected activity existed. Every DEA employee who was engaged in similar misconduct had either been terminated or had resigned while a termination was pending. As such, summary judgment should be affirmed with respect to Mrs. Kitlinski's USERRA claim. Plaintiffs have also failed to establish that Mr. Kitlinski was terminated for his USERRA protected activity. Again, plaintiffs must establish that Mr. Kitlinski engaged in USERRA protected activity and that activity motivated his termination. If he establishes that, the government must establish that it would have terminated him regardless of that activity. Here, Mr. Kitlinski was terminated for refusing to show up for his OPR interview after OPR had expressly coordinated with the Coast Guard to ensure his ability to attend, consistent with his military duties. Critically, as this court noted, there is nothing about Mr. Kitlinski's military duty that precluded him from attending the interview. The Coast Guard had expressly helped arrange the interview. Mr. Kitlinski testified that he first learned of the interview from the Coast Guard. And when Mr. Kitlinski learned of the interview, the Coast Guard even told him that he could have the OPR agents come to the Coast Guard if that would be easier for him. But he didn't even make that option available to OPR. He testified that he just refused to be interviewed, and the record demonstrates that as well. Mr. Kitlinski plainly remained a DEA employee while he was on military duty, and he behaved as such when it suited him. He had no problem leaving his post to hand deliver a DEA transfer request to the DEA in Arlington, to appear at an EEO interview at the DEA headquarters in Arlington, to attend an MSPB hearing regarding his DEA employment in San Francisco. Only when the Coast Guard and the DEA had made arrangements for him to attend the OPR interview did Mr. Kitlinski suddenly and unilaterally decide that he could not leave his post. The DEA handbook explains that DEA employees have an obligation to work with both the military and the DEA in good faith to ensure that the needs of the agency are met. And federal regulations for federal civilian employees on active reserve duty also make clear that a federal civilian agency can raise a need for a particular civilian employee within the military, with the military branch that employee is on active duty with, and the military and the agency work together to work it out. That's at 5 CFR 353.203, paragraph C. This is not a case where Mr. Kitlinski was fired because he was on military leave, like in Erickson v. U.S. Postal Service, or a case where he was not promoted because he had taken too much military leave, like Hayden v. Air Force. This is a case where Mr. Kitlinski unilaterally decided not to cooperate with an internal investigation that he and his wife had initiated after the Coast Guard had worked with the DEA to accommodate it. This is simply another attempt of the plaintiffs attempting to use USERRA as both a sword and a shield, insisting that the federal government investigate their allegations that somebody had illegally used a BlackBerry, and then trying to use USERRA to preclude the investigators from taking the most critical of investigating steps, interviewing the only two known witnesses in the circumstance. Second, the record makes clear that neither Mr. Kitlinski's military service nor any USERRA protected activity motivated his termination. He was terminated because he refused to attend the interview after the Coast Guard had helped to set it up. Mr. Bolgren explained that Mr. Kitlinski's job series as a drug enforcement agent and the fact that he was a senior supervisory employee required that he be held to the highest standard of conduct, which required him to participate in the investigation. And because plaintiffs failed to contest the facts that these reasons were the reasons for Mr. Kitlinski's termination at summary judgment, the district court deemed these facts admitted. And plaintiffs do not challenge here that these were the reasons for his termination. Finally, even if plaintiffs could establish that Mr. Kitlinski's USERRA protected activity had any role in his termination, defendant has fully established that Mr. Kitlinski would have been terminated regardless of his military service. All employees who refused to participate in an internal investigation were terminated or resigned while their terminations were pending. Again, plaintiffs admitted this fact at summary judgment and do not challenge it here. As such, the court should affirm summary judgment on Mr. Kitlinski's USERRA claim.
All right, thank you, Ms. Kimball. If either of my colleagues have any questions, I'd be happy to have them ask it. Judge Groh, do you have any questions?
No, not for Ms. Kimball. Thank you.
Judge Floyd, do you have any questions?
No, sir.
All right, I have no questions either. Thank you very much, Ms. Kimball.
Thank you.
All right, Mr. Burns, you have some
Yes,
you
Your
have
Honor.
some time for rebuttal. We'd be pleased to hear from you.
Thank you, Judge. Thank you all. I think the problem with the government's argument is its premise, which is that Lisa Kudlinski initiated an investigation and that both she and her husband refused to cooperate. The actual factual predicate is that there was a series of cases going on against the DEA by the Kudlinskis, including USERRA and EEO claims. When the BlackBerry was discovered, it was discovered after Mr. Kudlinski had testified at EEO headquarters. The DEA, Mr. Kudlinski reported this to the FBI as a criminal violation. And we know that that has resonance because the Federal Circuit, when addressing this issue on whether or not a cellular telephone's placement could be retaliation, said that that right arises under the Constitution for any citizen. So Mr. Kudlinski went to the FBI. The FBI didn't respond. He went to the Office of Inspector General, was told they were going to investigate. Then the Inspector General's office, their special agent in charge called Herman Whaley, told him about the phone. And the DEA began looking into not how the phone, who put the phone in the Kudlinski's car, but how the Kudlinskis discovered it, which is fairly clear from the investigative questions that were asked. The significant issue that's missing in the government's argument is that the Kudlinskis were complainants against the agency itself. They had a series of administrative claims going. and they had reported the agency's conduct to both the FBI and the OIG. That is why we wanted to talk to the Inspector General himself as to how this case got transferred to the DEA, because our presumption was that that was done by Herman Whaley speaking with the special agent in charge and transferring a case to the OPR. So the OPR investigation, which if you go back and look at the sheet, simply says investigation, doesn't even tell what it's about. The OPR investigators focused on, in questioning Ms. Kudlinski, how she discovered the phone, what her communications with her attorney were, what her communications, as the government just admitted, with the Office of Inspector General were, which is actually protected activity in and of itself. So when Lisa Kudlinski supposedly reported this, she reported it to a supervisor as a friend, and the agency had already begun investigating it independently. So the question then becomes, can an agency use its quasi-law enforcement power to force witnesses in an ongoing administrative case to come in and disclose the contents of that administrative investigation, the contents of their discussions with their attorneys, and the actions of their attorneys to an agency? And we think that under 5 U.S.C. 555 and under the statutes that exist, the answer to that is no. The second thing is USERRA is not dependent on the geography of Mr. Kudlinski, nor is it dependent on the voluntariness of his cooperation. The government continues to assert a false fact that the Coast Guard agreed to make Mr. Kudlinski, quote, present. All that happened was 2 DEA agents went over to the Coast Guard, represented themselves on a sheet of paper as Coast Guard employees, and were given authorization by a lieutenant commander on the security detail to simply talk to Mr. Kudlinski about matters the lieutenant commander did not know. And all the agents then came in and ordered Mr. Kudlinski to come off active duty.
Burns, Mr.
Yes.
Burns, there's a larger question here, I think. And the way you frame it, it's almost as if the Office of Professional Responsibility had no authority to do anything. It seems to me you would throw up roadblock after roadblock. And I think stepping back for a moment, it's very important that government agencies in law enforcement, such as the FBI and the DEA, be able to investigate wrongdoing in their own ranks.
Certainly.
It can be a real problem if there's an absence of integrity or law breaking or underhanded conduct within a law enforcement agency itself, because it would be a loss of public trust and an impairment of the mission. And my general concern here is that by raising one objection after another, you almost tie the hands of law enforcement in being able to root out internal problems, which I think we know that sometimes these agencies become very insular, and they need someone to take a broom to them and to find out what's going on. And you're coming close to saying that they can't even interview the people whose comments would be the most relevant. I don't think they were trying to broach any spousal privilege. They were simply trying to find out what was behind the BlackBerry and, why this was there, which she wanted looked into. And it just seems to me that you would be that what you're suggesting could be very damaging to the efforts of government agencies to really to run a clean shop and to get to the root of problems that can fester in these agencies.
If I may respond, Judge, I don't disagree with that, which is why we wrote letters to the DEA saying the DEA attorney, when we wrote her and questioned her about this and what we should do, she said everything needs to be litigated within the administrative process. So that's precisely what we did. When Derek Kedlinski was questioned, we did not object to him being interviewed. We objected to him being called off active duty without approval from his supervisor, and we objected to his attorney not being able to be present during that questioning because Mr. Kedlinski already had litigation against the agency. The way to resolve this amicably and reasonably would have been for the agency to respond to that request and say, Mr. Burns, please bring your client over because we know he's in an administrative claim. That would have not impeded their investigation in any way, shape, or form. If Lisa Kedlinski had been able to have me present because they questioned her while her husband was in a proceeding in San Francisco in which the senior-most DEA officials themselves testified, including Michelle Lenhart, that agent consciously chose that date because I was not present. And had I been present, we could have addressed all of those questions that weren't answered, which we did when we were in front of Mr. Bulgren. The issue is not whether the agency can investigate. The issue is when a litigant has ongoing administrative claims or judicial claims against an agency, can an agency use its law enforcement authority to call that witness in without counsel and simply pepper them with questions about their underlying allegations?
Whatever that might be, I wonder if we're not wandering fairly far afield from the subject of the complaint, which was that there was somehow anti-military animus that motivated this whole thing. I'm having difficulty.
Well,
obviously you've got problems with the agency,
right.
Fair enough, but I don't understand how anti-military animus even gets into that. It seems to me that most of the problems with the agency are, whatever they may be, are somewhat far afield from the Uniform Services Employment Act. And I'm having a hard time seeing how there was any anti-military animus. Coast wasn't objecting.
But the Coast Guard, the person at the Coast Guard, the only thing the Coast Guard granted, I want to get that clear, the only thing the Coast Guard granted was the access of the agents to go talk to Mr. Kedlinski. They didn't grant him access to leave his post. They didn't direct him to leave his post. And when I wrote to the agency and said, look, he's doing military service, can we work this out? They did not respond at all. They did not cooperate in that. So my point is that his military status was he was on active duty. The act itself says it's an employment and reemployment act, that while Mr. Kedlinski is on active duty, with all due respect, he is not the employee of the Coast Guard. And I know I'm out of—
Mr. Burns?
Yes.
This is Judge Sgro. Specifically, how would Mr. Kedlinski's service in the Coast Guard have been disrupted, or how would the Coast Guard's business have been disrupted if he had simply appeared for the deposition?
No, it wasn't. It was, the thing is, they gave him 1 day's notice, Your Honor. They said, come by tomorrow. And that's what we objected to. We said that is unreasonable for you to demand to leave his post on a day's notice. I mean, I think those facts get lost in this, that there were real attempts to work out with the agency a reasonable mechanism for them to be able to interview the Kedlinskis while preserving the Kedlinskis' rights so that the agency couldn't interfere with discovery or the administrative procedures of litigation against them. And that would have been quite simply to have me present. The problem with Mr. Kedlinski is that when he's on active duty service, it's the Employment and Reemployment Act, because while he's on active duty service, the statute says he's not employed by an employer. If you find that they can do this, then that sets a precedent that any civilian or government employer can simply go over to somebody on active duty and demand they come and do the agency's bidding. And Congress decided that is not how USERRA works. It protects the reservist status and it protects the active duty status of military members because of the necessity of their function.
The Coast Guard is not objecting here, and your opposing counsel points out that he left his active duty status to come across the country or do whatever on a number of occasions. Now, if there'd been some kind of objection from the Coast Guard, it would be something else. But its enabling statute says this, you know, that they should use its personnel, the Coast Guard should use its personnel to assist and cooperate with any federal agency. And one of the difficulties that I had was that both with respect to Derek and Lisa, and I don't guess Lisa's even in the military, is that there were no steps here that seemed to lead toward cooperation. It's just a flat refusal to attend the interview or to produce the BlackBerry, at least initially. Derek and Lisa even refused to produce the BlackBerry. They just, the problem is the record suggests there was just an absolute stonewall.
No, Judge, I think, and I'm over time, so I want to be able to answer this question. There wasn't a stonewall. If you look at the record, the government attorney, Letitia Pinckney, told me when I protested these actions that all of these matters had to be handled within the administrative case. We filed motions in those cases. We would have presented the BlackBerry to them in the course of discovery. We would have answered questions at a deposition. We would have returned and answered questions with the Kidlinskis, so long as I could be present so we could make sure they were not invading the administrative proceeding. There's a simple resolution to this, which is the thing every other law enforcement agency I've ever dealt with does. The FBI, the Marshal Service, is your attorney comes, particularly when you're a complainant against that very agency. For instance, under your scenario, the agency could call over, I could go to district court, file an employment complaint, and then the agency's OPR investigators could come out and interrogate my client about those matters while there's a pending action.
I understand you sometimes think you didn't get proper notice or whatever. I'm not sure that's our job to sort all that kind of thing out. But going back to what the complaint alleges, which was a violation of the USERRA, and again, whatever problems that these two plaintiffs had with the agency, it's just hard for me to connect it up. And there's all this back and forth, but it's hard for me to connect it up to the basic allegation of the complaint that there was some anti-military animus afoot here, because as far as I can tell, they're following a fairly standard set of rules and dismissing somebody who refuses to request an investigation and refuses to cooperate. And it seems to me that the agency's proceeding according to a standard procedure, but I just have a difficulty locating an anti-military animus, which is what this statute is very laudably designed to prevent.
Well, if I may just finish this, and I'll stop, Your Honor. What the statute does is...
Burns, you run over your time, but I want to make sure that you get your argument out. So why don't you give us a brief concluding statement, okay?
Certainly. Your Honors, I fully understand the view of the court, but there are factual issues that are in dispute. First of all, over whether the Coast Guard ever actually granted any authority for Mr. Kidlinski to leave. That's a factual question. We disagree with that. And the second issue is the understanding premise that we have is the statute protects the military status of Mr. Kidlinski. So anything that interferes with that military status or those military obligations violates USERRA. And we can't think of anything that would violate USERRA more than an agency coming over and on less than 24 hours notice, demanding somebody come over the next day and be interviewed.
All right. Mr. Burns, I thank you, and I'm going to ask Judge Floyd, do you have any questions you would like to ask of Mr. Burns?
No, sir.
Judge Groh, do you have any questions you would like to pose to Mr. Burns?
No, sir. Thank you.
Thank you.
All right. Mr. White, Mr. Burns, Ms. Kimball, we want to thank you all for your argument. But unfortunately, operating virtually, we're not able to come down and shake your hand the way we traditionally do. But we want you to understand we still appreciate your argument nonetheless. So thank you very much. And our court will take a brief recess, and I want to go directly into the next case, and we'll ask the courtroom deputy to move us into the next case.
Judge Wilkinson, do you want to go directly to the next case?
And I think the Supreme Court has been very, very clear about beginning with Justice Kennedy's opinion in Dinn and then going on through the adoption of Justice Kennedy's opinion by the full court. And it says that all that the consul needs to do is cite the relevant provision. And here they did more. But I honestly feel I'd be setting myself up, and the court might be setting itself up for a per curiam reversal if we started going into whether the facts of the case and what the consul did or didn't do or whatever. And because I think the Supreme Court realizes that granting or denial of visas are, there are thousands, multiple thousands of these that could be reviewed in court. And in reading the Supreme Court's opinion, it seemed to me it was sending an unmistakable message. Which Judge,
if I may interrupt.
Excuse me, which Judge Chazanow picked up on, and the message was hands off.
Your Honor, if I may explain the two issues we're raising. One is that whether the agency action was final to begin with, and whether the case was brought at the proper time. And that seems the judge herself is suggesting that we should go back to agency because there's still that channel is still open. So basically, what she's suggesting is that the action of the agency is not final. So that is the first issue. So if she wanted to dismiss the case based on APA and non-finality of the case, that would be one thing. The other thing is about Dean versus Kerry v. Dean, where the Justice Kennedy discussed the issue. And what Justice Kennedy did was, first, you need to make sure is there any facially legitimate reason for the denial at all. And in Dean's case, Ms. Dean's husband had admitted that she had worked with Taliban, and the case was not denied based on misrepresentation. The case had been denied based on terrorism ground. In terrorism ground, the statute is very clear. In terrorism ground, the statute says if the consular officer has any reason to believe there is any commitment to terrorism activities, they have the right to deny the case. So on that basis, Justice Kennedy said, okay, you admitted that you had worked with Taliban, and the consular officer had the reason to believe that you are inadmissible on that basis. So that was, and the fact that they told you what the statute was, and also what the fact that you worked with Taliban was part of it, that's enough. Here in
Counsel, my difficulty with your argument remains whether we looked at the Dean case or whether we look at the Mandel case or the Kleindinks or wherever or whether we look at the other circuit cases where the Seventh Circuit just recently says the doctrine of consular non-reviewability makes it impossible or nearly so for plaintiffs to challenge a visa denial. But I just do not see either the authority of under the statute, which gives us a right to review this, and I don't see the authority anywhere in the Supreme Court. And I honestly believe I really do not like being the object of a per curiam reversal, and I'm afraid that would be how abrupt it would become. Sometimes in law your hands are just tied, and I think Judge Chazanow, who's really very fine district judge absolutely recognized that.
Your Honor, I don't like to bring the cases to courts either. And the parents of this kid, Mr. Cisse and his children that are separated are not happy with it either. I totally understand why the law has been set up the way it is and has given more authority to consular officers to have a higher level of discretion to deny visas to people who have either committed crimes or who have been, there is a possibility that they have been involved in terrorist activities. But in this ground for misrepresentation, that is not the case. In fact, this court itself has specifically ruled that for misrepresentation cases, government has the burden of proving with clear and convincing evidence and bringing substantial amount of evidence that there is a misrepresentation to begin with. Here we have no proof whatsoever that there is a misrepresentation. There is not even one single document on the record that the government is providing to say this one is showing her age is different. They only are talking about their conclusion because they call it totality of information, and I think that's not correct because that totality of information should include also the record of this kid's birth, and we have provided quite a bit of it. Judge in the district court has said, has followed Dean and says, okay, in Dean, Judge Kennedy is mentioning a statute is enough, plus they have given you more facts. Yes, in terrorism ground, they could do that. And now judge in our case says, here they're saying the statute for misrepresentation and they're telling you passport is, they think the passport is not right. They think the passport is not right does not make the passport wrong. There are some there are government agencies in Sierra Leone who are issuing passport. There are government agencies in Sierra Leone who are issuing the birth certificate. Unless the government is talking about basically saying kids who are not taking those tests, they should have, government think they should have taken it anyway. And unless the government thinks that they have the right to impose some new legal requirements for issuance of the visa, and because of that, order people that they have to study, that they have to take tests and bring it. And I mean, I need to see on what basis they think that a national test result is more important in terms of showing somebody's date of birth than the person's birthday. And unless the government thinks that Sierra Leone does not have the right to govern itself and to decide which government agencies to issue their own legal documents, the government here doesn't have any right whatsoever to impose and tell people what kind of, to tell people how they should present their age. The government in Sierra Leone has issued the birth certificate. We don't have anything else, in terms of hospital records, in terms of even a transcript of Mabinti's previous years, everything has been provided, and every single thing points to the fact that her date of birth is May 21, 2000. There's not even one single document that says otherwise. So government has a burden of proving that she is not telling the truth. And what they're doing is they're just based on mere conclusion of why Mabinti's father has talked to her mom to ask whether she has taken test or not. Therefore, we decided, based on totality of circumstances, as they call it, since she has not taken MPSE, therefore she's lying. Not every kid has taken a test. Not every kid is literate.
Problem here, as I'm trying to explain, is that we don't have, nor does the district court have, by virtue of Supreme Court authority or by Congress, we don't have the authority to look into the adequacy of documentation in every visa application.
Your Honor, you do have the authority to ask government to provide substantial information, substantial documentation to show misrepresentation to begin with. And on top of that, to show how is that a material fact. That is actually what you have done for another case in Zine, I believe that's the case.
I'm trying to explain to you that we don't have the authority to review the adequacy of documentation, and we don't have the authority to make credibility findings with respect to visa applications. We don't have that authority. The district court doesn't have that authority. The Supreme Court has made clear that we don't have the authority. Congress has not passed a statute that would give the alien abroad or to challenge the denial of a visa. I think if we started down the road of judicial review, we would be brought up short. I just want you to understand.
Your Honor, I understand this is a difficult
I'm not trying to be peremptory. I'm trying to just let you understand
Yes.
that our hands, at least as I see it, are tied.
I totally understand that your hands are tied in terms of requiring documents, but the decision in APA cases are supposed to be done based on the complete record. And government has not provided anything on the record to the contrary to what we have provided. On that basis, they cannot even assert misrepresentation to begin with, let alone the fact that they are even considering that to be a material fact here. There is the only thing that we have is apparently during the interview, the consular officer was trying to force Mabinti to say that she is 19 years old, and she was saying she's 17 years old. Nevertheless, 19 years old at the time of interview is still under 21 at the time of application of I-130. So there is no material fact here whatsoever by their own admission on that basis, and they are not even providing anything at all. And the fact that they're trying to just make this whole conclusion of the law instead of actually analyzing of the law and providing us information, providing basically facts that show misrepresentation, rather deciding because they think so. They think she's older, therefore she is older. And truth of the matter is, when they asked for the test result and she didn't have it, about 7-8 months later, she became eligible and she finally took the test, and we finally presented the result of the test. And at that point, they were not even considering it. And the government and the court did have the authority to make the defendants to consider the new documents. The court here did not even go there.
Mr. Fatahi, I want to thank you for your argument. You have some time for rebuttal. Judge Floyd, do you have any questions you wish to ask Mr. Fatahi?
Ms. Fatahi.
No, sir. I agree with your position.
Yep. Judge Groh, do you have any questions you wish to ask Mr. Fatahi?
I do not, sir. I don't see how the district court could have gotten around the DCN.
Excuse me, I didn't hear that.
I don't see how the district court could have gotten around the DCN or the principle that the consular's decision to deny the visa is immune from judicial review.
Yeah. All right. Thank you. And Mr. Fatahi, you have some time for rebuttal. And Mr. Lazaro, we look forward to hearing from you.
Thank you very much, Your Honor. It's Alan Lazaro from the U.S. Attorney's Office in Baltimore for the appellees. I'll try to be brief. I want to start with a comment that opposing counsel made multiple times during her opening argument, that the government bears a burden by clear and convincing evidence. Now, the appellants devote pages of their opening brief to citing cases, none of which are consular non-reviewability cases. They're asylum cases, they're denaturalization cases, they're deportation cases, and in those contexts, the government does bear a burden. But that burden is inapplicable here to cases like the one at bar, which involves a visa applicant that's applying from abroad. In situations like ours, 8 U.S.C. 1361 provides that it's not the government's burden of proof, it's the visa applicant's burden of proof. And if they fail to establish to the satisfaction of the consular officer an entitlement to a visa, then no titlement should issue. And again, that's very different from other contexts, for instance, the deportation context, where by regulation, the government does bear a burden of proving deportability by clear and convincing evidence. So the court should reject appellant's attempt to graft an analysis from different contexts to this context to which the consular non-reviewability doctrine applies. The only burden the government has is to provide a facially legitimate and bona fide reason for the denial. And in that, as the court has pointed out, we look at Justice Kennedy's controlling opinion, which has now been adopted by the full Supreme Court in Hawaii. And the consular officer satisfied that burden at page 101 of the joint appendix by informing Mabinti that she was ineligible for a visa, citing to and referencing the statutory language. And we think the analysis really can end there on that prong of the analysis, because there are any number of circuit-level decisions, some of which involve the very same inadmissibility statute at issue in our case, that have considered Justice Kennedy's opinion in the context of a consular non-reviewability application, and have held that where the consular officer cited a valid inadmissibility statute, that's where the analysis ends. But
with respect to Section 1182 A6CI, it's not challenged that that's the applicable statute, is it? That's the applicable statute from our perspective, and I don't understand there to be a challenge from the other perspective on that point either. The analysis can end there, but it actually doesn't have to end there, because in this case, the government actually did much more than reference the statute. There have been some cases that we think perhaps incorrectly have seized on some language in Justice Kennedy's opinion, and they've asked, well, is there a facial connection between the inadmissibility statute referenced and the facts of a particular case? And in this case, it's quite simple to find that facial connection just by looking at just a few brief data points from the chronology. On November 14th, 2017, at the very first consular interview, the appellants admitted in the complaint below that the consular officer accused plaintiff Mabinti of lying about her age. We then fast forward 3 days, there's a provisional denial under INA 221G, but the consular officer informs Mabinti that she can provide more documentation. And what documentation is that? That's documentation tending to prove her age. We then fast forward, litigation is filed, and then in no less than 3 times, the State Department at pages 66, 99, and 162 informs appellants and appellants counsel that the visa application is being denied finally, but because Mabinti misrepresented her age and presented a false passport. So this process was one that started with the consular officer questioning the veracity of Mabinti's claims about her age, and ended with an explanation that the visa was being denied because she lied about her age. That certainly bears a facial connection to the referenced inadmissibility statute, which is for fraud or material misrepresentation. So to the extent that something more is required, which we don't think it is, we have that additional facial connection in this case. And I would also point out that we would actually also pass muster under Justice Breyer's dissent in Din, which stated that one of the ways the government could satisfy its burden is to give the factual basis for the government's decision. Here we have the factual basis that Mabinti lied about her age and presented a passport in a false identity. Now, appellant's counsel said, well, Din is different because Din is a terrorism case. Din has not been limited to related cases. It's been applied to fraud and misrepresentation cases like the inadmissibility statute at issue in our case. That's the Seventh Circuit's case in Matushkina, and the Second Circuit's 2018 opinion in Zhang. I think as this court has recognized now with the benefit of Hawaii now recognizing that Justice Kennedy's opinion was the controlling opinion, and the court in Hawaii recognized that in Din, Justice Kennedy noted that the government need provide only a statutory citation to a visa denial and didn't limit it to terrorism cases.
If
Is there
the
anything further, Mr. Lazaro?
No, Your Honor. I'll stop there.
Do either of my colleagues have any questions? Judge Floyd, do you have any questions?
No, sir.
Judge Groh?
No, sir.
All right. Thank you very much, Mr. Lazaro. Mr. Fatai, you've reserved some time for rebuttal, and we'd be happy to hear from you.
Your Honor, I want to go back to the two issues that we raised. First, again, the court should be deciding whether the APA final action agency was actually met at the time the case was filed. Just because the government attorney asserted that it is and we mistakenly accepted it doesn't make the law any different. And even as we can see, the judge herself in her opinion is talking about the fact that we can seek our reconsideration through the agency still, even at the time, like that was almost a year after the case had been already filed. So if the case want to be dismissed based on APA and not non-final agency action, that's a different story. But in here, government is now basically arguing the violation of INA should be within a context. First, the inadmissibility provisions that are placed in the INA are inadmissibility. Basically, admissibility happens in two times. Once when the person is applying inside the US for green card, or when the person applies outside of the government, goes through consular processing and comes to the US with an immigrant visa, which is what Mabinti did. There is a reason there are these different provisions of law, specifically some based on, I don't know, public health, based on terrorism ground, based on crime, or based on misrepresentation has been placed in the INA. Each one is having a different standard that should be applied for the decision as to whether or not this person is able to be coming to the US or not and get the visa or not. So just because it should not, when the government is arguing that we argue several cases based on asylum or all sort of different kind of context, but not within the context of consular non-reviewability. Well, because there was no such a thing before. This is a new thing since 2017 that's happening. We had never seen anything like it before, that the children of US citizens are going to the consulate and they're not been getting visa because the consulate thinks they're lying since there is no test taking. That is an absolutely bogus ground. This is like out of imagination. This is just like a made up excuse. And that is exactly the reason that it should be investigated. And you do have the authority to investigate it. Just because the case might be decided otherwise at the Supreme Court level, it doesn't mean we should shy away from it. And I didn't shy away from it, regardless of how challenging it is and how difficult it is. And there might be sometimes the first time for everything. So you don't want to be, at the same time, what the government is arguing here is about facial connection. They're constantly trying to bring this word facial connection into context here. There is no such a thing as facial connection in any of the case law. But what there is the facial, the denial should be based on a facially legitimate. And Justice Kennedy also explains that means it should be reasonable within the context of the law. That's why Justice Kennedy, in fact, went through the law based on the terrorism ground of inadmissibility, analyzed it, and then reached the conclusion that it was reasonable because the law allows the consular officer only to have the reason to believe that there is a violation and therefore deny the case. Here in this context of willful misrepresentation of material facts, just stating the statute and also saying, oh, by the way, it is facially connected to passports. It does not meet the burden because even this court itself has found that this ground of inadmissibility requires substantial documentation, and all of this should be on the record. There is not even one single document that says otherwise about Mabinti's age. The fact that they are trying to reach conclusion based on no reason shows their bad faith. And as for her age, they never mention what is her age. Not just providing anything. They're not ever mentioning anything simply because they really don't have anything. And there is really nothing anyway to begin with. As to Dean has been applied in other cases, is being applied here or there. Well, I'm taking it that when people are not challenging the matter and they're not standing up to what's happening based on what we've been seeing in the past 4 years, of course it's going to start being applied here or there. It doesn't mean it's right. And it doesn't mean we shouldn't stand up to it. And what I would like you to understand is the other side of the challenge is by allowing government to randomly, like this, denying children of US citizens from coming to the United States, regardless of how complete their documentations are, you're basically giving government a blank check to deny these cases without ever being held accountable. Government.
All right, Mr. Fatahi, I want to thank you for your argument. We appreciate that, and we appreciate Mr. Lazaro's argument. And as I mentioned in the previous case, it's disappointing that we can't come down and shake your hands and thank you in person, but we do appreciate it. And I'll ask the courtroom deputy to give us a 5-minute recess, and then we will move into our third case and the last one that will be oral argued. So we'll take a 5-minute recess, okay?
Okay.
This honorable court will take a brief recess.
Mr. Largess, when you're ready.
Thank you. May it please the court. This is Luke Largess here on behalf of Michael Jones. This is a classic pretext case, and the court below made two fundamental errors. One, fully crediting Lowe's disengagement claims and evidence as a justification for the termination. And second, finding that the evidence of dishonesty in this assessment process was immaterial and could not be considered by a jury. Let me take you through each of those quickly. First, the problem with the disengagement evidence, the jury could readily disregard or reject it and disbelieve it. The timing is the first problem. The court focuses mainly on these alleged confrontational discussions about severance and cleaning out the office back in April and May. But the termination is in the last days of October. There's no real connection between those discussions and what happens. And there's no evidence supporting disengagement in that time except the following. Subjective perceptions that he was not checking in and not participating enough, with no record of any complaint. Claim that his hours were reduced, but we produced calendars showing that in fact that was completely not true, that his hours remained the same, his schedule remained as busy as ever. And then finally, the only objective complaint was the need to call or email him to ask why he was not on the agenda for a single meeting in 5 months. The jury could readily decide in this case that Mr. Jones, who in his prima facie case here is extraordinary, a black man, the first black man to have any significant management authority at Lowe's, leads the company through a dramatic transformation of its fortunes, bringing in new talent and new methods that has results that he is acclaimed for both inside and outside the company. A jury could find that he continued to act in that same manner from May until his termination. And there's record evidence of examples of him doing that. The third problem, which relates to the sort of second piece here, is that there is evidence of dishonesty. And the jury could assess this disengagement claim with circumspection at the way this assessment process was handled. Let me begin with a couple aspects about the assessment. The first is the court's simply wrong to say there's disputed evidence about whether this was a CEO assessment or some broader executive development effort. In fact, if you look at page 2624 of the record, you'll find the August 2015 single-page CEO succession plan that was presented to Lowe's board by Ms. Asura, who was then the HR person. If you look at page 2794, you'll find the testimony of the board member, Morgan, who said the board decided to bring in an outside consultant to do an in-depth study of these two men and what their skills were to decide who should be the internal successor. And that resulted in objective testing, psychological testing, and surveys of other employees. And if you compare page 733 of the record to page 2300, and especially page 1120 of the record to page 2370, you see these graphs and measures that show that Mr. Jones was superior to Mr. Maltzberger clearly in this process. But then you have this subjective assessment about the competencies that, ironic, and this is at page 734 for Mr. Jones and 2302 for Mr. Maltzberger. But Mr. Niblock admits at page 149 and 150 of the record that he never believed these results. But it's undisputed that for the month of May, he and Ms. Weber scrivened away at the CEO profile. Look at page 750, 1442, and 1153.
Let me ask you one thing, Mr. Largess. Is it undisputed that he was asking for a $9 million severance package prior to his termination?
Not prior to his termination, Your Honor. That was in the negotiations afterward. And actually, I think that that is actually evidence of discrimination in this case for this reason. The proxy statements that are in the record show that he had more than $9 million in stock options issued to him while he was leading the resurgence of this company. Just in 2014 and 15, 2015 and 16, he was owed that. But because he was fired, he lost.
When did he request the severance package?
Well, you might be confusing two issues. Back in April and May, when he was presented with, after they spent the month of May trying to rewrite this profile to make these competencies the linchpin of who should be the CEO successor, and he balked at the validity of it, and Niblock agrees that it was invalid. He then said, rather than fire me, and his testimony is, if you look at page 261 of the record, that Ms. Weber met with him and told him he had to word for word repeat that he couldn't do those three things. That's what they wanted him to do. And he balked at doing that. And he said, if you're going to fire me, if you don't want me here, let's just work out a severance. They had that discussion 4 times, all in the context of them demanding that he accept that he had lacked basic competencies and him expressing his reluctance to do so. And saying, if what you're telling me is you don't want me here, let's work out some separation. And this is after leading this company on the road.
What is do you have a comparator here?
The comparator is Mr. Maltzberger. In this sense, in terms of the assessment process, yeah, and if you put the documents side by side, I just suggested some that 733 and 2300, for example, you can see they're doing these comparisons. Those are the only two who are attested that way in this process. And then but here's the question, Your Honor, is that if it was offensive for him to bring up severance as a way of resolving this dispute in April, why was he fired in October? Why wait? What justified what sort of transgression or did he do to bring on termination? And there's nothing in the record. The justification that the court accepted and put in its order was that it would be awkward to have him before the board because I'd already told the board I thought I had reservations about his engagement. But that report to the board in August came at the same time that Dr. Rivers, the consultant, explained that all of their efforts to revise this assessment process had not changed her assessment of these two men, and that Jones remained the more capable successor. So then we get to this critical series of meetings in October, which is what leads to the termination. Dr. Rivers comes on October 17th, and she brings with her her report to the board. And here the court gets this wrong. It says that she brought.
Why is this anything other than an assessment of Maltzberger and Jones, and who's going to make the best successor to Niblock? Why isn't this just what companies do all the time, which is to weigh the relative merits, which involves certain objective but also certain subjective components, and decide who is best qualified to lead the company when one individual steps down? And it seems that for a long time, Mr. Niblock was grooming Jones for the position, and that he was going to be the drop dead successor.
Actually, that's disputed, Your Honor.
All right, well,
It's important to understand that that is a.
Well, I'm asking, reading the record here, it seemed to me that Jones was being groomed, and for a long time he had the inside track, and I don't understand why this is necessarily racial discrimination as opposed to just looking at two people and deciding that one is more suitable for the company's needs.
Your Honor, don't be confused here. The racial discrimination issue in the case is determination. And the import of the assessment is, it is the sort of thing that happens all the time, although Lowe's had never done this before. They never brought in an outside consultant because it had always been the prerogative of the CEO. And it's very disputed that Mr. Jones' testimony is that it was clear that Mr. Niblock favored Mr. Maltzberger to be his successor all the way along. And Ms. Weber described that he had a clear affinity for Maltzberger in going through this assessment process with him. The issue is that he fires him, and then he and Weber dramatically modified Dr. Weber's assessment of Maltzberger to whitewash it and present a completely contrived and played. If you look at the document, here's the comparison. I was trying to get to this. On October 16th, she brings her report, October 17th rather, she brings her report at 2248 of the record. And it's not this assessment of every executive, it's Maltzberger and Jones, and they brought in a third, McDermott, and they are ranked on graphs. It's a comparison, like you're talking about, Judge, it's a comparison. But the whole thing has backfired because she rates Jones and Maltzberger both as very high risk now because of all this kind of controversy, I guess. But the assessment of the summary assessment of Jones is still extremely positive, and the summary assessment of Maltzberger is very, very negative in parts, that he has fundamental problems as a leader of people.
So, well, maybe so, maybe not. But when Maltzberger looked to have the inside track, wasn't it at that point that Mr. Jones became disengaged, and even to the point of cleaning out his office? Because this is a kind of thing that happens a good deal of the time, that you have two people who are in the running for the top position at a particular company, and it becomes clear that one of them is going to get the position, and then the one who's not going to get the position loses interest because his goal and ambition is not going to be fulfilled. And so the person who,
Your Honor, if I may,
just doesn't put the same amount into the job and is just marking time.
But the jury, Your Honor, the jury could believe in this case that simply did not.
In this case, was there not an objective manifestation of marking time when he cleaned out his office? I mean,
can I respond to that, Your Honor?
If somebody cleans out their office, somebody worked for me or worked in a company where I was working, if they cleaned out their office, it would communicate to me, well, they don't much care. That they're not
Your Honor,
all in.
The record's a little different here on this. What the record shows is that Mr. Jones moved some of the things in his cabinets out because he had been threatened with termination if he did not accept that he couldn't, these invalid competency ratings that Mr. Niblock later agreed were not valid scores. He is told, his version of the reason for packing up is that he thought he was about to be fired. And he was asking for severance rather than be fired. And that's the reason. And that's the issue. He doesn't get fired for 5 more months. And so and there's no manifestation of disengagement from that encounter in April and May to October, where he's doing everything that he had been doing. He's the one who's making money for the company. Mr. Maltzberger's division is in the red. Every aspect of what he's doing. The person who's carrying the load at Lowe's is Mr. Jones. And the issue here isn't, a jury could disbelieve that he became disengaged and could find that this, as the district court reacted when it saw this unexplained change in the assessment document and asked, it ruled that a jury could disbelieve the disengagement issue, and then turned around and said, because there was no promotion out of the assessment, the dishonesty in the process was immaterial. That's the legal issue, one of the legal issues in this case. The jury could disbelieve disengagement and find dishonesty. Thank you.
But as a matter of business practice, if, as you say, one individual is producing a lot of profits and one individual is running a loss, why would a company fire the individual who is producing the profits? I mean, it doesn't make, if it's as clear cut as you say, it doesn't make sense to me, because businesses are attuned to the bottom line. And I don't understand just from a standpoint of dollars and cents.
Well, Your Honor, I mean,
why would make sense to dismiss who is producing.
I'm sorry, Your Honor. It's hard to, I don't mean to be interrupting you. It's hard to do it over the phone like this. But here's a piece of evidence that you really need to see. Just because it answers your question. Race discrimination is irrational. It doesn't make sense. But on May 17th of 2016, for the first time in 7 years, since 2009, Lowe's beat Home Depot in a quarter on comparable sales. For the first time in 7 years. That same week, Mr. Niblock and Ms. Weber rewrote the CEO profile to move profitability down to second in priorities of the company, and moved some of Mr. Maltzberger's skills or visionary stuff about, omni-channel stuff and all the, ways of reaching customers. And he said that was a higher calling than making a profit. That's irrational. You just said it was. And that's at the heart of the sort of bizarreness of this process. They were deliberately dishonest for whatever reason, so that Mr. Maltzberger would come out ahead in this process, because that's the end that Niblock wanted. And when he couldn't get it.
Why is this a matter of race rather than just human chemistry?
At this point,
sometimes people have good chemistry and sometimes they don't, and that happens within a company. But why is this a matter of racial discrimination as opposed to just a matter of who gets along with whom?
Well, that's the issue for trial, Your Honor, whether this is race or something else. But we get to trial because the jury could disbelieve the disengagement claim and could find evidence of duplicity and mendacity in the way they handled the assessment. And that, under all of your case law, from St. Mary's Honor Center down, that's how you get to trial, by if the jury can disbelieve the justification here that he became disengaged and finds evidence of dishonesty, particularly if they can find that, then you get to trial. And at the trial, we figure out whether this is just chemistry between people or whether the jury decides this is in fact race discrimination. And that's all we're asking, that we should have a trial about that question.
All right, I'm going to ask you if any of my colleagues have any questions for you. Judge Floyd?
No, sir.
Judge Grove?
Yes, sir. Counsel, you agree there is a categorical difference between favoring one person over another simply because of the chemistry and favoring one person over another because of race, correct?
Well, it's sometimes a subtle categorical difference, and that's the question. That would be the question in this case, and that's the question in every race discrimination case. Was there something other than race that was driving the differential in treatment, or was it more likely than not race a factor?
I had some trouble in reviewing your brief finding concrete examples of discrimination. Can you point to one or a few for me?
Well, one would be what I was trying to explain at the end. After he's fired, that he knows of 2 white executives who did not qualify for their stock when they were separated from the company during his tenure. And they got their stock through a special request by the board or a special dispensation. And he asks for the same when he's let go, and they do a public pillory of him that he's greedy. He was being treated completely differently than 2 white executives as that instance. But again, the question here is, under the framework, Your Honor, the question isn't having to prove race, it's having to show that the jury would disbelieve the justification, and that's enough to get to trial. But especially if on top of that, there's evidence of dishonesty in the way that they handled this matter. And Judge Bell correctly reacted in court when he saw this dramatic alteration of the work that Rivers had done, taking away every criticism that she had of Maltzberger and whitewashing it. This would be like an employee being fired for taking issue with some aspect of a personnel evaluation, and then the Black employee, and then the white employee not only doesn't get fired, but all of the criticisms in his evaluation get removed. That's what happened here, and it doesn't make any sense. And race is the best, at least is an explanation of that. And under the rubric, we don't have to, there is stuff in the record about their interactions and there's a lot of racial issues at the company. But that's not the
question. I'm not sure whether it's a question for trial or not, but the question is whether this isn't just a judgment on the part of the company that one person is better suited for the long range needs of the company than someone else. I mean,
well, but that what you have here, Judge, is an outside person saying that Mr. Jones is far superiorly suited, and Mr. Niblock tries to undercut that. That's the issue related to the assessment. It's him going against the outside.
What I'm asking you is every time 2 individuals are compared for their suitability for a particular position, it doesn't necessarily create an issue of triable fact.
But that's not the issue.
That race, but at any rate, we've given you a good amount of time.
Yeah, I appreciate that.
Have some rebuttal time.
If I could just say this, Your Honor, the issue that we're not claiming race discrimination in the assessment, we're claiming race discrimination in the termination. In the assessment.
All right, I understand you. Okay.
Thank you.
Thank you, Mr. Largess. Mr. Raphael, let's hear your view of it.
Thank you, Judge Wilkinson. May it please the court, Stuart Raphael for Lowe's Companies. The district court correctly granted summary judgment to Lowe's on the race discrimination claims, and there's no dispute that the analysis is the same under both Section 1981 and North Carolina law. Judge Bell correctly granted summary judgment because the plaintiff failed to adduce sufficient evidence on either, number one, that Niblock's stated reason for Jones' termination was untrue, or that the real reason was because Jones is African American. At the third step of the McDonnell-Douglas test, and under this court's decisions in cases like Guesses, once Lowe's proffered a non-discriminatory reason for the termination, the burden shifted back to Jones to prove, number one, that the stated reason for the adverse action was untrue and was a pretext, and number two, that the true reason was discriminatory. And those 2 embedded elements are key. Since the briefing in this case, and we did drop a footnote and file a Rule 28J letter about this, the Supreme Court decided the Comcast decision, and that case holds that but-for causation is required to prevail in the Section 1981 case. And that makes 1981 different from other statutes like USERRA and Title VII, which allow a motivating factor analysis. So I think the question at the end of the day for the court and for Mr. Largess is, where in the record is there any evidence to show that but for Mr. Jones's race, he would not have been fired? And the answer is simply there is no evidence to show that. I want to start with the evidence that corroborates the non-discriminatory reason for his termination, that he had become disengaged and cleaned out of his office. There are 7 examples from the record that I think corroborate that. Number one, it's undisputed that Jones began looking for jobs, working on his resume as early as January 4, 2016. That's before the Hay assessment even took place. He emailed a resume writer saying that it was now time for him to start looking at jobs at Fortune 500 companies in a CEO position. That's at page 460 of the record. And remember that there was no question at this time, there was no plan for Niblock to leave as the CEO of Lowe's. He was expected to be there for another 3 to 5 years at least. Number two, it's undisputed that the very next day after Jones sent that email to a resume writer, he wrote himself a note, and this is at page 463 of the joint appendix. The note was talking about what was working for Lowe's economically. He said it was long-term growth and short-term profitability. But then he's talking about leaving. He says, my timeline, this quote, my timeline is too short to spend 3 to 5 years waiting for the business to figure this out, unquote. And we detail in our brief the various job efforts he made to find another job at other companies. Number three, it's undisputed that Jones repeatedly suggested to both Niblock and other senior executives that he be given a separation package so he could, quote, move on. That's at pages, for example, 255 and 1767 of the joint appendix. That clearly shows disengagement. Number four, to Judge Wilkinson's point, it's undisputed that Jones cleaned out his office acting like he was going to be let go. He testified that he thought he was going to be let go. And imagine the effect that that has on the morale of others. That's a clear corroboration of disengagement. And Jones admits at page 256 that Niblock told him he was acting childishly by cleaning out his office in the view of other employees. Fifth point, it's undisputed that Human Resources Vice President Andrew Ellis told Niblock a week before Niblock terminated Jones that Ellis thought that Jones had become disengaged and should be let go, that he had checked out from his job. That's a quote from Mr. Ellis. That's at page 466, paragraph 9. Now, Mr. Jones suggests in his reply brief at page 15 that this fact is contested, but it is not. He contests a different fact about a conversation between Ellis and Jones that took place after Jones was fired. We described this disagreement at footnote 3 of our brief, and we're not relying on that because that fact is disputed. But it's undisputed that Ellis told Niblock a week before he fired Jones that he thought Jones should go, even though Ellis had previously supported him and thought he was a really great employee. Number 6, it's undisputed that board members in August of 2016 noted the negative changes in Jones's behavior and asked Niblock about it. That's at page 1768 and 2193 of the joint appendix. And lastly, last point I'd make, Niblock testified without contradiction that he perceived Jones to be less engaged. And he cited as an example Jones leaving early from a key customer meeting in Charlotte. That's at page 1767 of the joint appendix. And there's no response by Mr. Jones to that fact in his brief. He wants to say, well, Jones kept coming to work and all that, but we're not saying he stopped working. We're saying that Niblock perceived him to be disengaged, and that's fully corroborated by the record. Moreover, this is not a case where the employer's reason changes or is based on post hoc rationales. Niblock's stated reason has been consistent throughout the case. So this case is governed by cases like Sheriff from 2016, where the court cited the employer's consistent reasons for why summary judgment was appropriate. And this case is therefore distinguishable from cases like Jacobs from 2015 that Mr. Largesse relied on in his opening brief, where the reasons given by the employer weren't given at the time, changed consistently, and there was significant evidence that the employer was making up reasons for what was a discriminatory discharge. The court in Lovett versus Cracker Barrel distinguished Jacobs as not applying where you have a consistent reason given by the employer and the reasons are corroborated in the record. Now let me turn to the other aspect of the analysis, and that is, where is the evidence of racial animus, or that the stated reason was a pretext for discrimination on the basis of race? There was zero evidence presented to show this. Jones also failed to overcome the same actor inference that the person who had previously promoted him, and Judge Wilkinson, you're exactly right, Niblock was grooming Jones to be a successor. There's ample evidence to show that. I need to make a few corrections in my friend's statements in his reply brief. He says at page 4 of the reply brief that Niblock was not the one who actually promoted Jones to the chief customer officer position. He claims that fact is disputed. That is simply untrue. Bridgeford, who occupied that position, he testified that while he had recommended Jones, Niblock was the one who actually appointed him because Jones reported to Niblock. That's at page 443 of the joint appendix. Bridgeford also testified that while he was the one who initially hired Jones in 2013, he made sure that he had Niblock's approval to do so. That's at page 443. And Jones admitted that he knew that Niblock had approved him. That's at page 1412. Mr. Largess is not correct that Jones was the first African-American to report to Niblock. He was the second. That's at page 56 of the joint appendix. The current CEO, incidentally, of Lowe's is African-American. That's at page 184. And Maltzberger, who Mr. Largess talks about, he never succeeded. He did not succeed Niblock as the CEO, and he's no longer at the company. Second point on the racial animus piece is that Niblock did not recommend, the plaintiff claims that Niblock did not recommend Jones as his hit by the bus successor in 2015. Obviously, this is a key issue is because it goes to the idea that Niblock was very supportive of Jones, and it's very unlikely that he would then turn around and want him fired. But the evidence that Niblock recommended Jones as his hit by the bus successor is undisputed. It's at page 1706 and 1707 of the joint appendix, and at page 2652. Niblock testified that he did recommend Jones in 2015 as his hit by the bus successor. Board member Morgan corroborated that at page 2793 of the joint appendix. And this is actually quite an interesting point. We're talking about August of 2015. At that time, the board understood that the long-term prospects for successors for Niblock were Maltzberger and Jones. And you'll see that chart at page 2624, talking about them as possible long-term successors. So at the very time that the board understands that Jones and Maltzberger are the potential long-term successors, Niblock is saying, if I'm hit by a bus, I want Jones to succeed me. I mean, that I think really demonstrates Judge Wilkinson's observation that Niblock really was grooming Jones to be the long-term successor. And their evidence—
What caused the falling out?
Your Honor, what we think happened was Jones saw that Niblock was not leaving. He, beginning in January of 2016, started to look for other jobs. He overreacted to the Hay Group assessment, which was overwhelmingly positive. But as in any leadership assessment, there were some constructive criticisms in there. He completely overreacted to them. He talks about the Hay assessment as if there was something that said he was a terrible leader. But Mr. Largess doesn't even tell you where that is in the assessment, right? He just completely overreacted to it. He became petulant about it. And at the same time, he was looking for other jobs. So it's a really unfortunate thing that happened, but this was not Lowe's doing. And the fact that Niblock gave him an opportunity to do better, Mr. Largess tries to make an issue out of the timing there, but Niblock, the cleaning out of the office incident reflected childish behavior by Jones. That was in June and July of 2016. And Niblock is trying to give him a chance. He tells him, you got to get your head in the game. If we want you as a member of the team, and things just didn't improve. And that's why Niblock ultimately terminated him. Further to that point, it's undisputed that Niblock gave Jones a glowing performance review in February 2016. This is before the Hay Group assessment came back. That February 2016 reviews at page 650 of the joint appendix. And he also gave Jones glowing reviews as part of the Hay assessment itself. His comments are found at pages 1111 and 1112 of the joint appendix. So getting back to the same actor inference, which dates to Your Honor's decision in Proud, this is a classic case for applying the same actor inference. The main argument against it is Largess says, well, Proud involved a 6-month period, and here you have a 30-month period or longer. But this court's on-bank decision in Taylor involved a 27-month period. The employee there was hired in August in August of 92 and fired in November of 94. 27 months later, you have a 30-month period here, so it's very comparable to the period in Taylor. And during that time, and I'm running that time from the time Niblock appointed Jones as the chief customer officer in April 2014. He ultimately terminated him in October 2016. That's 30 months later. But in the interim, he's designating him, appointing him, recommending him as his hit by the bus successor. He's giving him glowing performance reviews in February and April of 2016, and he terminates him in October 2016 after the petulant reaction he had to the Hay Group assessment, and he didn't get his head back in the game. So this is clearly an appropriate case for applying the same actor inference. And Mr. Largess has no explanation why Mr. Niblock would have turned around and fired him after having promoted him so much. He tries to generate a factual dispute out of the idea that the board didn't accept Niblock's recommendation that Jones should be the hit by the bus successor. But when you look at Morgan's explanation for why that was, it was because the board understood that Maltzberger and Jones were the two likely successors, and they didn't want to pick Jones and create ill will with Maltzberger. That's at page 2793 and 94 of the joint appendix. But what it shows is Niblock is very supportive of Jones, not the picture that Mr. Largess is trying to paint. The only time that the plaintiff came close to suggesting anything relating to racial animus is not even argued in the reply brief, or and I think has been dropped. But I for fear that it may come up in rebuttal argument, I do want to touch on it. And we addressed this in our opening in our brief. There were alleged stray remarks by Niblock referring to the show Blackish and referring to the Donald, when Donald builds the wall comment. They're mentioned obliquely in the statement of facts in the opening brief. We pointed out in our appellee's brief that argument was not made below on the motion for summary judgment, and it was not contained in the argument section of the opening brief and is therefore waived. Mr. Largess dropped it in his reply brief, but I just want to make it clear that those stray remarks, which don't even connect to any action by Niblock, are not proper in the case. And in any event,
sometimes falling outs just happen. I mean, they're unfortunate, but it's often just when two people get along, or when two people don't get along, or whatever. That happens for many different reasons, and it isn't necessarily something that relates to race. It's just that people get along, and sometimes people don't get along. And just looking at the record, I'm just wondering that seems to be what's going on. What's going on here? There was, for the longest amount of time, a very laudable attempt to give Mr. Jones a very meaningful role in the company. That was a good thing. And he was given a good chance. And I'm for one, I'm sorry it didn't work out, but I'm sorry things fell apart for whatever reason. But just doesn't find it hard to attribute it to race in the sense of creating a triable issue on that point. I wanted to ask you, there was also a defamation claim in this case, and I noted with some interest that our esteemed friend and colleague Judge Wynn on the North Carolina Court of Appeals wrote a good opinion saying that a negative assessment of an employee is not defamatory under North Carolina law, and that Lowe's was simply exercising a right also to reply when Jones assailed the reputation of the company. But anyway, it didn't.
Yes.
The defamation claim seems to fall for a number of reasons. That a lot of the statements were either statements of opinion or they were absolutely true, and neither category is actionable.
Yes, Your Honor. I think that's exactly right. If the court affirms on that there was no Section 1981 discrimination, I think the defamation claim does fall. In response to your observations, you're exactly right. North Carolina law, and I like you, Judge Wilkins, I come from grew up in Virginia under Virginia law. I was quite surprised to see how clearly North Carolina law prohibits a defamation per se claim based on a statement that an employee was dishonest or untruthful or unreliable. And Judge Wynn's opinion in Losing versus Food Lion is an excellent example of that. Mr. Largess argues in his reply brief that North Carolina law distinguishes between libel and slander in that regard, and somehow that distinction doesn't apply to libel claims. That's just not true. And the three North Carolina district court cases that we cite in footnote 15 of our brief are examples of libel claims where the court said North Carolina law doesn't provide a defamation per se claim based on calling an employee untruthful or unreliable.
You have anything further, Mr. Raphael?
Yeah, yes, Your Honor. If the one thing in this case that would warrant publication, I think, is on the qualified privilege of reply under Fortich, because here you had a very reputable company assailed by a television news station about being engaged in race discrimination, and it simply defended itself by putting out a statement at page 508 of why it didn't discriminate against Mr. Jones on the basis of race. That is plainly covered within the privilege of reply, and I think the court would do
right. Well, you've covered that in your brief.
Yes, Your Honor. So we would ask the court to affirm on the basis of the 41-page opinion by Judge Bell that was exactly right on the law. Thank you, Your Honor.
Wait a minute. Hold on, Judge Floyd. Did you have any questions?
No, sir.
Judge Groh, do you have any questions of Mr. Raphael?
No, sir.
All right. We thank you very much, Mr. Raphael, and I want to make sure that Mr. Largess gets in his time for rebuttal. Mr. Largess, we are happy to hear from you in rebuttal.
Thank you, Your Honor. Let me start with a few things. First of all, it is not the case under the law that we have to prove that race was a factor at this stage. We have to only prove at this stage that a jury could disbelieve the evidence, the claim of disengagement, and find some mendacity in the way the matter was handled. This case went off the rails, as you say, Your Honor, very obviously. And it's at the document, you said you didn't point to it, but the document of this sort of competencies is at page 734 for Mr. Jones and 2302 for Mr. Maltzberger. It's the only aspect of the assessment where Mr. Maltzberger scored ahead. And the issue isn't whether Mr. Jones the question is whether Mr. Jones was petulant at being told he couldn't do those basic things, couldn't lead a senior team, he got a 0. Or whether he was threatened with termination if he didn't accept it. And his evidence, which a jury could believe, is that he was threatened. And that's why he had the reaction he did to the process, not out of some sort of childishness, but out of the very, on April 22nd, the second ranking Black employee in the company, the former the second rank in HR, was fired precipitously 7 weeks after Ms. Weber came aboard. On the Monday, she came in and said to him, "Are you ready now to accept the competencies?" So,
Mr. Largess, one of the points that Mr. Raphael made seemed to resonated with me. And that involves the cleaning out of his office, and that fact troubles me because whether you think you're going to be terminated or not, if you are, there's plenty of time after you've been terminated when you can clean out your office. But to be cleaning out your office while you're still on the company's payroll, that seems to me to send a pretty clear signal that you're not engaged, or that you've just given up on whatever relationship you had with the company. And Mr. Raphael made the point.
Your Honor, if I may, but the day after,
could I please ask?
Go ahead. I'm sorry.
I know you believe in your case, and that's very commendable, and I only respect you for that. But the point that I'm making is that it is extremely, I would think it would be extremely demoralizing to be working next to someone or across the hall from someone and find that they've just cleaned out their office. It gins up rumors, number one, and you don't want to, everybody's trying hard to make the company work, and you don't want one person in the company who had held or continued to hold a very senior and responsible management job to just say, I'm out of here, or to clean out the office. It's almost a symbol of cutting ties.
May I respond, Your Honor?
That part of it, part of it really bothered me.
I understand, and again, two things. One is that what Mr. Jones did is he had brought a bunch of stuff with him from Husqvarna and GE, his prior work, that were in cabinets, out of view anyway, and he cleaned out those cabinets because he would thought that if he was going to be fired, he would be walked out, just like he was walked out the day he was fired. And he wanted to be able to carry all of the things in a box so that he could be on his way. He thought he was going to be fired in days, Your Honor, at the time that he did that. And what he did in response was he went to Boston the next week and gave a glowing report on Lowe's future to a group of investors who wrote a letter back saying it was the best presentation at the session. He wrote to his team about doing this campaign with Walgreens to look at cost-cutting measures. He went and traveled to stores and met with store managers and assistant managers and got reports back that in the 16 years with Lowe's, they'd never seen anything like it. The evidence is that he was completely engaged and professional, trying to figure out how to navigate this unexpected development where he was being told that in this process, he had to accept that he couldn't lead people. And he had reluctance about that. And the question is whether he acted as he did because he was threatened or because he was immature. And you seem to be taking the position that as a matter of fact, him doing that is proof of disengagement when it's proof of fear that he's being terminated. And that for the 5 months after that was in May, not in June and July, that was in May. And from then until October, the only thing identified in the record as a concern were two things. One is that he left one meeting early and that he had to be reminded to come to another meeting in 5 months. So there is a record here where a jury could just disbelieve that it's too convenient to have this disengagement issue. And that because Mr. Niblock was cynical in putting this competency thing for him and making it the linchpin of this succession process.
Well, the point I think is that, or one point is that when normally you have a question of pretextuality, it's sort of shifting here and there and all over the place, and you have explanations that are inconsistent and are in fact at odds with one another. But here it does seem to me that there's a certain consistency in the explanation, which is that he'd become disengaged, and I don't think they really put forward anything else. And you have other members of the board of management indicating that in their view, their perception, he was disengaged. And then you have a certain corroboration, even though I understand the company wasn't aware of this right at the time, but that he was actively hunting for new jobs. And at some point, at some point, all of these little pieces begin to add up to a picture of someone who was in fact disengaged. And if you had another explanation, or if the company's explanations were shifting or furtive or whatever, then I think you'd have an issue of triable fact. But
Your Honor, may I respond?
On this record that you do.
But Your Honor, what you just said, there is no board member who testified that they had concerns. Mr. Niblock testified that board members said things to him. But the only evidence in the record is in August, out of the blue, he sends for the first time an email saying that he has some concerns about Jones' level of engagement. And that is right at the same time that Dr. Rivers has come back and said that her assessment, Jones is still the superior candidate, even though they've tried to rewrite the profile. And it's that leads to his termination and then the revision of Maltzberger's assessment. It's rank dishonesty combined with the jury's ability to objectively, Your Honor, again, the only criticism Mr. Niblock had was that he missed a meeting or left a meeting early once in 5 months. If you look at let me find you this page, 2775 of the record, which are the notes about the interview of Mr. Maltzberger when they reopened the assessment. Look at the last page. Mr. Maltzberger was missing CEO staff meetings, sending a message that he doesn't need to be there. Everyone else goes. So they're firing him because he left one meeting early and had to be reminded to attend another. But Mr. Maltzberger, who has all criticisms wiped clean of his assessment, is not going to regular staff meetings. That's disengagement. And there are other people on those same pages saying that he doesn't show up. He's never here. Why is he away so much? Mr. Jones is the one who was keeping this company on course during all this time when he's being demanded to accept that he can't lead people. And he just balked at doing that. And he did not interview with anyone until after all that, Your Honor. And his only reason in January for putting a feeler out to have his resume was he anticipated exactly what was going to happen here, that this process was going to be used against him. And it's the dishonesty in that process and the fact that objectively he continued to produce and keep the company's ship steaming. He's the one who's motivating people, going around and leading these programs. On the day he's fired, are all his notes from meetings the day before on short and long-range planning. He has been still completely engaged in trying to be professional. And Mr. Raphael reads this thing about Blackish, but that was in the record. But the more important thing that was in this brief is in August, he went to Human Resources and complained that they were running all the black HR executives out of the company and that there was a concern about racial issues in the company. That is right at the time when he sends his note to jump to the board saying he has some concerns about his level of engagement.
All right. Thank you very much, Mr. Largess.
Thank you.
I appreciate your argument. And I want to say both to you and Mr. Raphael that, again, as I've said at the earlier cases, I'm really sorry that the coronavirus prevents us from coming down and shaking hands with you personally and thanking you. I thought on both sides that these arguments were very well presented, and so on behalf of the panel, I'd like to thank you both. And I'm going to ask at this point that the courtroom deputy adjourn court and then put us into a conference setting with after about a 5-minute break. And Ms. Walker, thank you for the nice job that you've done. We appreciate that as well.
Thank you, Your Honor.
Thank you, Your Honor.
This honorable court stands adjourned until until this afternoon. God save the United States and this honorable court.
Judges, I'm going to go ahead and move you all into the virtual robing room, but you can break it just anytime. When you come back, you should be in that room and ready to conference, okay?
So we'll be in a conference setting.
Yes.
All right, well,